Recording in progress.
Good morning, honorable members, colleagues from the department, Dr. Naidu and the team, our legal team and our support team, Honorable Sepuru from Limpopo, who has joined us, and other colleagues from provinces. Let me take this opportunity to welcome you all to this cooperative governance, public service and administration, human settlement and water and sanitation select committee. It gives me great pleasure to declare this meeting opened. We are now going to be moving straight to the apologies, Mr. Manele, if any. I know one of the Honorable Minister, Hlabisa, who's also committed in the cabinet, who's unable to join us. Mr. Manele, any further apologies?
Good morning, Chairperson. Chair, officially we have only one apology from the Chief Whip. Thank you very much, Chairperson.
Okay. There are two members whom I think they've joined us today. Is Honorable Kaza here?
No, Chairperson, let me just try to call him, but I'm aware that is...
I'm told that is writing exams as well.
Yes, Chairperson.
Okay. Let's note that if he's not here, let's then proceed. Honorable members, let me also thank you for your level of commitments you have displayed during our oversight visit in Nazna, and members were really committed to do our work, and we were able to execute our responsibility when we're there to interact with stakeholders. Next week, we'll be having the same engagement with Nala community and stakeholders to process the invocation, the application for invocation of Section 1391B in that municipality in Free State. I'm hoping that members have been conducted in terms of the logistics, processing our departure on the 14th after I'm sure we'll show our faces during the presentation or responses by the President on the questions. Then when the time allows us to take leave, we'll be at liberty to take leave so that we can make it for our flight to Free State. The following week, we'll be engaging on another engagement in the Northwest Province. We'll combine the two visits, Gauteng and Northwest Province. We'll be having a joint program. We are still going to be meeting to finalize some nitty-gritties with the chairperson of infrastructure and his team and my team to conclude on the program. But we'll also expect members also to avail themselves so that we continue to execute our responsibilities as this committee. Really, the level of commitment and dedication that you are showing to the work that you are doing in this committee. It's really outstanding. Thank you very much for that. I know they say that says you can't thank the fish for swimming, but here it's important that we acknowledge your level of commitment. Without any further ado, I know we have omitted the adoption of the agenda in our main agenda today. Can I call for the mover for the adoption of the agenda that is tabled before us?
Chair, Honorable
Honorable
Murkomen.
Pedenost.
Thank you, Chair. I'll move for the adoption.
Thank you. Honorable Zimande.
I second, Chair.
Thank you very much. The agenda is now duly adopted. Members, today we are called to deal with the negotiating mandates from our provinces on the Independent Municipal Demarcation Authority Bill, which has been processed by provinces. Then the department will come in and the legal team to respond on what provinces have raised. And then after that, we'll then have a discussion on the issues that are before us. Then we'll consider the minutes and we'll close our meeting. This is how the agenda will be flowing. Without any further delay, let me call upon provinces. This is how we are going to kickstart this process. The last time we did it the other way around. Now it's us as provinces tabling our provincial mandates. Then the department will come to respond, and the legal team will also come. Then we have deliberations, then we close the meeting. Can I request the team to put the provincial mandates on the screen?
Chair, Dr. Naidu will open the folder with the negotiating mandate. Dr. Naidu?
Okay. Thank you very much, Dr. Naidu. Let's start with the first province, Eastern Cape. Honorable Peter, are you ready? Here is your mandate. Honorable Peter, let me call upon you to present the mandate of the Eastern Cape province. Honorable Peter, are you there? It looks like Honorable Peter is not on the platform. Is not here on the platform. Anyone from the provincial legislature of Eastern Cape? Okay, let's move to another province. We'll come back. Mr. Manuel, let's look for Honorable Peter. We now move to the Free State. In Free State, we've got 3 members. Honorable Briet, Honorable Steve Cocher, Honorable Makesini. Can you talk at the same time? Okay, you can talk on their behalf.
Okay, Chairperson, thank you. I'm not going to go through all the details, but it's in terms of the Independent Municipal Demarcation Authority Bill. The date of the deliberation was 7th of May 2025, and the vote of the legislature, the Portfolio Committee on Cooperative Governance and Office of the Premier, as designated by the Free State Legislature, votes in favor of the bill. I thank you.
Thank you very much, Honorable Briet. Next province. Okay. It's up and down, this one.
Surely it can't be Gauteng.
It's look like Gauteng, eh?
Chair, can I just make a comment if I may?
Yes,
Well-
Honorable President Host.
It would have been really helpful if these negotiating mandates were sent to us as committee members prior to this meeting so that we could have the assistance of a written document at hand, and it would have also helped us to speed up this process that we're going through now.
Okay, I thought the team have sent it. Let's apologize if that was not done, because that's what we agreed upon. That is Gauteng now coming. Our apologies for that, members.
No, thanks, Chair.
Honorable Nzimande.
Thank you, Chair. The name of the bill, Independent Municipal Demarcation Authority Bill, B14B 2022. The date of deliberation by the Gauteng legislature, it was the 24th June 2025. The legislature of Gauteng is supporting the Independent Municipal Demarcation Authority Bill, subject to the amendment as set out below. Thank you.
Thank you, Honorable Nzimande. Next province. Do we have a representative from KZN? Oh, Honorable Kaunda, let's call upon him to present the mandate from his province. This is the bill number B14B dash 2022. The deliberations were held on the 9th of May 2025. The COGTA Portfolio Committee met on Friday, the 9th of May, and agreed to mandate the KwaZulu-Natal delegation to support the Independent Municipal Demarcation Authority Bill. That bill number reflected with the following amendments and or comments attached here to in the committee report to support the bill. Thank you very much. That's the mandate from KZN. Next province. Limpopo, Honorable Whip of our committee, Honorable Molokome.
Thank you, Chairperson. Good morning, honorable members on the platform, and greetings to the Chair of Limpopo, Honorable Sipuru. No, thanks, Chair. The Independent Municipal Demarcation Authority, which is the IMDB Bill 14B, was referred to the legislature of Limpopo by the National Council of Provinces, and the meeting, the public hearing was conducted on the 3rd of September 2025 at Meropa, and the portfolio committee met on the 8th of September 2025 for the consideration of the bill, and it was agreed upon by the committee to process the bill and solicit both oral and written this one.
Yeah, there's a recommendation there.
Yeah, let me go to the recommendation. The portfolio committee, having considered the above input from the stakeholders, It recommended to confer the bill to the NCOP permanent delegate to vote in favor of the negotiating mandate, subject to the above mentioned comments and input. Thanks, Chair.
Thank you very much, Honorable Whip, Honorable Molokome. You are accompanied by your chair, and thank you very much for the presence of the chairperson. Let's move to the next province. Mpumalanga. Who's going to take Mpumalanga? Are there any recommendations there? Is there anyone from Mpumalanga? It looked like the committee considered the matter as reflected, and they mandated the delegates to vote in favor of the bill with proposed suggestions. So Mpumalanga is also in support. Next province is Honorable Peter Beck. Northern Cape. Let's move to the recommendations. We received an apology from the Chief Whip, but the Northern Cape has also considered the matter, and the committee adopted this negotiating mandate duly assigned by the chairperson. The committee recommends to the House to mandate permanent delegates to participate in deliberations at the negotiating stage and to support the bill. Thank you. Northwest, Honorable Mabibo, Hoshi Mabibo.
Good morning, Chairperson.
Let's move to the recommendations.
Yes.
Morning,
Let me
morning. Over to you, Hoshi Mabibo. Recommendations, please.
Yes, a recommendation. The Portfolio Committee on Bill B14B /2022. The province adopted and they are in support of the bill of the demarcation. Thank you very much.
Thank you very much, Hoshi Mabibo. Western Cape. Honorable Berenhorst.
Yeah, I'm just trying to find the summary of it, Chair.
I think it's on the top, on the first paragraph there.
Yeah, it's normally on the cover page. That's the committee's report. That's the comments on the different clauses. It's really not helpful not to have a printed copy with me. I'm sorry, Chair, I'm reliant on what I see on the screen.
Can we move? Is there anything that talks on the mandates there? No. Right on the top, there was a statement and the numbering of the bill after the logo. Yes. Yes, it's there. The second paragraph.
Okay, I've got it.
Honorable-
Thank you, Chair. Thank you, Chair. The Standing Committee on Local Government, Environmental Affairs and Development Planning, having considered the subject of the Independent Municipal Demarcation Authority Bill B14B 2022, referred to the committee in accordance with Standing Rule 217, confers on the Western Cape delegation in the NCOP the authority not to support the bill in its current form and proposes amendments as reflected in this report. Thank you, Chair.
Thank you very much, Honorable Bedenost. The province is not in support as per the condition that they've put there. Can we revert to the Eastern Cape? Honorable Peter, are you back? Maybe he thought the meeting is physical. Maybe it's there at the NCOP building. Yeah, if we look at they confer the mandate to the permanent delegates, you just moved it now. To the permanent delegates representing the Eastern Cape Provincial Legislature in the National Council of Provinces to negotiate in favor of the bill with the proposed amendments. Thank you very much. We are done. Is there any province that we have omitted? I think we have dealt with 9 provinces. The only province we have not touched is international. So I think all the provinces located here, they have been recorded. Now, the next process, honorable members, is to allow the department through Dr. Naidu to respond on the issues that are raised on these mandates from provinces, so that we can also allow legal team to put their perspective, thereafter engage. Over to you, Dr. Naidu and your team.
Chairperson, I didn't hear Northern Cape.
Yes, they were not here, but I read on their behalf. They were in support. Thank you.
Chair, how many provinces supported and those who are not in support? If we can get that indication, Chair.
It's only Western Cape, which is not in support of the bill as it has been tabled. So it means 8 provinces were in support, of course, raising their own issues, but they were in support of the bill, and Western Cape not in support. Thank you. You can proceed, Dr. Naidu.
Thank you very much, Honorable Chairperson. Good morning to you. Good morning to the other honorable members in the Select Committee. Colleagues, Honorable Chair, what we have done, which is in the document that we will take the committee through, is to construct it such that we have the negotiating mandates as received from each of the provinces. We've got them in alphabetical order. we have included a column that speaks to the clause in the bill. For ease of reference, we've included in another column adjacent to that the current provision in the bill. It makes it a lot easier to provide the context in relation to the negotiating mandates that have been, or the comments or the inputs that have been provided by the different provincial legislatures. And we have, as far as possible, tried to summarize it, paraphrase it, without losing the meaning that has been provided or communicated by the legislatures. In the last column on the right, we provide the departmental response, either supporting, noting, not supporting, confirming that the input or comment made is indeed already provided for in the bill. And that is how we have constructed this document, Honorable Chairperson. So if we start with the Eastern Cape, for example, and we confirm that the province, the legislature had voted in favor of the bill, but had also made the following proposals in their submission. The first, in relation to the appointment of board members, which is dealt with in clause 10 of the bill, it says that proposes that the addition of and qualification be included in the bill. We have supported the proposal, Chair, and indicated that we will, when it comes to redrafting, when it comes to the development of the C list, that the C list also accommodate this proposal that had come from the province. So in relation to the board members, that was the proposal, but it was also suggested the same that should be done for the members of the committees that the board would establish. So here too, we have supported the proposal that had come from the province. This is repeated in other submissions from other provincial legislatures, Honourable Chair. So at that point, we will go through the submission more swiftly. The next proposal that had come from the legislature dealt with the notification when dealing with the redetermination or determination of boundaries. And it had indicated that because radio broadcasting has broader reach, we should also include that in the bill as a medium for the board to also use when communicating matters of this nature. We agree, and we therefore have supported the submission, which will then be subjected to the drafting team to include or to deal with when the bill is being revised. The next submission dealt with clause 29, and here too it deals with consultation, similar notion to increase the reach to communities and to use radio as a medium to communicate matters of determination or redetermination of municipal boundaries. So we've supported that and will be covered in the C list. The next submission made related to the criteria to be considered when delimiting wards. And in the proposal that had come through from the provincial legislature, it had suggested that the population of the affected area be a consideration. We're of the view that the matter is already covered in the provisions in the bill as it is. And if you look at the third column, we indicate the provision which requires that density of population needs to be considered when wards are delimited. So it is already catered for. We move to the next clause, which deals with public participation in clause 36 of the bill. Here also, the suggestion that radio as a medium be used for communicating or to entrenching public participation be used. We have also supported the submission from the provincial legislature, and then will be subjected to redrafting. If you look at the extreme right, you would see a purple color and a blue color. The purple color was what was in the initial document that was circulated to the committee. It was an error. It should have read 36.2 instead of 26.2. So we're just bringing that to the attention of the members of the committee. The next submission from the provincial legislature was in relation to the Appeals Authority, clause 38 in particular. And the suggestion was that the Appeals Authority too must be independent, impartial, and perform its functions without fear or favor. We have supported that, and we will include that in the C-list version of the bill as well. Clause 43, in relation to proceedings of the Appeals Authority, the notion or the submission was that the Appeals Authority should look at a longer time frame when looking at appeals that are coming through. We want to say here, Honorable Chair and members of the committee, that we have not supported this submission. It is a submission that is repeated later on in the document coming from another provincial legislature, and not supported because the matter of demarcation, delimitation is a process that is very time-bound. One is on the clock in relation to finalizing matters as expeditiously as possible. You would know in other provisions in the bill, we provide for a timetable that the board would publish, pretty much like the timetable that the IEC publishes when it comes to elections, either at the national, provincial, or local government level. So to ensure that timeframes are not compromised, we have not supported it, meaning that we would want to stick to the 30 days that is provided for objections. The next clause deals with clause 47 in relation to municipal capacity assessments. And you would see that this is a matter that is repeated quite often in the document as we will go through it. But the submission that had come through from the provincial legislature was that a municipality, in essence, must cooperate with the authority. We believe that this matter is already covered in the bill, and the yellow highlight that you see in the existing provision says to us that there has to be that collaboration between the municipality and the authority when it comes to matters dealing with capacity assessments. We then come to the Free State, which has also voted in favor of the bill with proposals for amendments to provisions in the bill as we have it presently. The first is in relation to the composition of the board, and the provision that has been recommended, or the proposal made, is that the clause be amended to state that the board must broadly reflect the composition, ensuring that professional qualification remain the primary basis of appointments. We believe, Honourable Chair, that the matter is covered already in the formulation of the provisions that we have before us. In clause 8, dealing with the responsibilities of the board, the proposal is that the board must act independently at all times. We believe that it is already provided for. If you look at the left-hand side, clause 4A of the bill says that the authority must be independent, impartial, and perform its functions without fear favor, or prejudice. In clause 9, the proposal was that clause 9.2 must be amended to ensure that the disqualification is extended to include individuals who have previously held political positions for a period of at least 12 months after holding public or political office. We support this proposal, Chair, and we would want to engage with our legal team and legal drafters to see how best it is incorporated into the bill without affecting the rights of any persons that fall into that category. In clause 10, which deals with the appointment of the board members, and this too is a proposal that has been replicated in other submissions that we have received. And the proposal here indicates that including political figures in the selection panel raises concerns regarding potential influence, and that an alternative approach should be considered, which could include a parliamentary selection process. We've noted that, but we would want to say to the committee that the proposal or the proposed manner in which the selection panel is constituted is indicated as we have highlighted in the second column, which is a panel chaired by the Chief Justice, by a person, includes a person with specific knowledge of demarcation, and which is done designated by the Minister after consultation with the MECs. It has a person designated by organized local government. It includes the Commission for Gender Equality, the Portfolio Committee Chair for COGTA in the National Assembly, the Chairperson of the Select Committee in the NCOP, and then also the Chairperson of the National House of Traditional and Khoisan Leaders. So we believe that this selection panel is more representative. It is all encompassing of the various sectors, and therefore should stay the way it is. Clause 16, which deals with committees, there were more than one submission in relation to this matter. The first being that there should be clear guidelines to govern the formation and operation of such committees, and that there should be a limitation on the number of members that can be co-opted. We believe that this is presently already provided for in the bill, and therefore noted without making any further submissions, any further revisions to the provisions as we have it. Clause 16 still dealing with committees, that co-opted members should fulfill the requirements as set out in 9.1. We support it, but what we have done here, or the proposal that we would want to make to the drafters, is that the entire Section 9 becomes applicable to members of the committee. And to do so, we want to suggest the deletion of Clause 9.2 in the bill. This too is repeated by submissions from other provinces as well. The next submission from the provincial legislature was that for transparency, it is suggested that the board members may be required to disclose any political party memberships or positions. We do not support this, and we believe that by having the provisions as we have in the bill presently, where a person holding a political office is barred, is enough to ensure that the matter of political influence is dealt with appropriately as we have it. The next submission from the Provincial Legislature of the Free State dealt with Clause 23 around the determination of boundaries, but more specifically around the objectives of boundary determinations. And it firstly says in relation to Clause 23(1)(e), clarification is needed to understand the implications of this assessment criterion. And then in 23(2), the clauses broad reference to adherence to provisions within the SPLUMA is not specific, and therefore greater clarity is necessary to ensure compliance and implementation. So as a team, when we had met, we had also engaged the Demarcation Board in relation to the various submissions that we received. We noted, but our submission is that the clause is not solely intended to deal with capacity assessments, but rather to ensure that any municipal boundary results in an entity to execute the powers conferred to it by the Minister and the MEC. In relation to the Clause 23(2) submission, our view is that the board needs to consider the broad principles of SPLUMA, such as spatial injustice, spatial sustainability, efficiency, etc., when it goes about the redetermination and determination of municipal boundaries. So we believe that the manner in which it is constructed presently is fine the way it is. The next submission was on Clause 32 and dealing specifically when boundary redetermination or determination takes effect. And the submission was that it should be extended from the current 6 months or the proposed 6 months to 9 months. And we believe that perhaps it may have been an oversight because at the instance that the bill was being processed in the Portfolio Committee, such a submission was also received, and we're in agreement that the 9 months is what we would take into the revision or the redrafting of the bill. The next submission deals with Clause 38, more specifically the establishment and the constitution of the Appeal Authority. And the submission is that it lacks a comprehensive evaluation mechanism. We have noted that, and we believe that it is a matter that we will consider when the regulations are being developed to complement the implementation of the Independent Municipal Demarcation Act. The next submission from the Gauteng Provincial Legislature, which supported the bill, the first was that there should be an insertion of the definition of organized local government. We supported it, and we will import from the Systems Act the definition that is there already. The next proposal dealt with Clause 7, dealing with the composition of the board. And the submission that we had received, as indicated in the fourth column, the second last column from the right, is that as it removes the requirements of reflect regional diversity or regional society, and provides that the composition of the board must broadly reflect composition of the South African society. We've noted this, but this is something that when the selection panel is established, it is something that is considered as part of the criteria to be considered when making recommendations to the president after a selection process. The next submission related to Clause 8, dealing with the responsibilities of the board. And here too, as repeated up above, for the board to act independently at all times with unfettered discretion. Honorable Chair, we believe here too this matter has been covered in clause 4 in the formulation that we have there presently. The next submission was in relation to section 11 on the term of office of board members. And here the submission is that the president, and I'm just focusing on the, as far as possible, the summary without losing the essence of it. The president is at liberty to remove a board member for the subjective reason that the minister has lost confidence in him or her. And this opens a door for the removal of anyone for purposes of political expediency with no recourse to the individual. We have noted this. We would want to subject this to a discussion with the legal drafters to see how best we are able to accommodate this concern. But suffice to say, Honorable Chair, when you look at the third column and the way the present provisions in the bill are formulated, all of those matters 1 to 5, as listed there, misconduct, continued ill health, etc., are matters that would still be subjected to departure when the president applies his mind when it comes to removal of board members. The next submission was in relation to clause 16, section 16 of the bill. And here too, the submission that co-opted members should fulfill the requirements set out in section 9.1. As indicated up above, we support it, and we will propose a redrafting such that the entire section 9 applies to committees. The next submission was to provide limitations on the number of members that can be co-opted. We have not supported this because we believe that the provisions, especially in section 15, is ample enough to ensure that this matter or possible risk as perceived is mitigated against. The next submission was on clause 26 and the instance of initiation of municipal boundary processes. The submission received was that there should be an inclusion of private individuals with an independent board of unelected individuals so that there can be no compromise when it comes to the authority of local government in its affairs. We have noted this, and we believe that the matter is not related to the considering of the 10-year cycle, but rather providing for a 10-year cycle for major boundary redeterminations. In relation to the second matter that was raised, the co-option to be only done when the authority does not have appropriate skills and capacity to perform certain required functions as may be deemed necessary by the board. The next submission was in relation to clause 35, which deals with the criteria for the delimitation of wards. Here too, this matter has been repeated below. And it deals with the 30% and the 15% norm. So the deviation of 15%, the legislature indicates was reasonable, but that the 30% may make a huge difference among the wards. We have not supported a reformulation because we believe that the proposal that is in the bill is something that is very, very necessary. And it is something that we hope will help address the challenges faced when it comes to the splitting of traditional communities, etc. The splitting of communities, farms, and the areas of traditional and Khoisan leadership. And we believe that this needs to be there, something that is absolutely necessary to ensure that communities are kept intact, and farms, etc. Clause 40 deals with the qualifications of members of the appeals authority. And the submission from the legislature was that ordinary citizens are not given a chance to be part of the board. We have not supported it because we believe that the bill in its present form offers an equal opportunity for all persons to apply for to be a member of the board, as well as an opportunity to be a part of the appeals authority. The next submission was in relation to clause 41, which deals with the term of office of the appeals authority. In trying to summarize the submission from the legislature, the broad points related to the rationalization of municipalities. It focused on the matters relating to provincial boundaries, and then also the formula to determine the number of councillors. The submission also indicated that if municipalities merge, smaller municipalities then appear to be underrepresented in the new municipality. Honourable Chair, we've noted the submission, but we believe that the introduction of the 10-year cycle for the determination or redetermination of major boundary changes is intended to limit the challenges associated with amalgamations, but also to provide more stability in municipalities that have already been established. In relation to the alteration of provincial boundaries, this matter falls outside the purview of the Municipal Demarcation Board, or the authority as it will be known in the future. And there's a defined process in the Constitution that deals with the alteration of provincial boundaries. Any change in the provincial boundary is subject to the Constitution, and with that requiring the required majorities as indicated therein. In relation to funding, this is dealt with through appropriations from the National Treasury. Furthermore, clause 24C of the bill compels the board when determining or redetermining boundaries, and it's very specific to say that the financial viability and the administrative capacity of the municipality must be considered to perform municipal functions efficiently and effectively. The next submission was in relation to capacity assessments. The reference in the submission dealt with section 41, but that deals with the term of office of members of appeals authority, whereas we believe the correct reference should have been section 47 dealing with municipal capacity assessments. The submission received was that during the demarcation process, the MDB should conduct feasibility studies / investigations in all cases to better inform the implications of redetermining boundaries. We've noted that, Chair, and we say that the bill already compels the authority to conduct municipal capacity assessments in clause 47, and then investigations in terms of clause 28 of the bill. So we believe it is adequately dealt with in the bill as we have it presently. The next submission dealt with mergers, and in the first instance, the provincial legislature recommended that the 3-year budgets should be provided by the National Treasury for such mergers. The National Treasury should continue to monitor and support. And then thirdly, when merging municipality, the board does not take note of the financial viability of the municipalities. Perhaps on the last point, as just indicated, there's a specific provision, and I think it is 24E, that requires the board to ensure that it takes into consideration the financial viability and administrative capacity of municipalities. Clause 26.1 states that the board may only determine the boundary regarding the categorization, amalgamation, or any boundary change after every 10 years. The next submission related to clause 26 and the initiation of the municipal boundary process. And in line with the municipal boundary redetermination, it is proposed that the ward delimitations should be done after 10 years. We have not supported this because we believe that it could run into constitutional problems when it comes to equality and proportional representation, because with migration patterns as we have it, ward delimitation is necessary to ensure that we are within the confines of the law, more especially the 15% norm that has to be in place from one ward to another in a specific municipality. And as we have been proposing in the bill, the 30% becomes an exception to the norm under very specific conditions. The next submission was a general comment, and it was indicated that the provincial representation of provincial officers be a fixture for the board. Here too, we believe that it is already provided for in various other provisions in the bill as we have it, and we've indicated here under highlights that the authority can do all that is necessary or expedient to perform its functions effectively, which includes the powers it has to determine its own staff establishment, which could include the provincialization of its officers. Suffice to say, Honourable Chair, that we have been part of various engagements with the National Treasury to see how best we're able to support this process of provincialization. Of course, resources, financial resources, becomes a major factor in effectuating that. The next submission was in relation to capacity assessments, and the provincial legislature has indicated that it is unclear the exact purpose of the capacity assessment. We have taken note of that, but we believe that the requirement for the board to undertake municipal capacity assessments is an absolute necessity, which it uses as its primary source to inform boundary changes, without which it becomes very difficult to come to a conclusion as to how a boundary should be constructed. Which takes us to the submission by the next provincial legislature, KwaZulu-Natal, which has also voted in favor of the bill. Here too, and it is something that has been dealt with above, a submission that requires the publication of the names to be included, but also their qualifications of the members of the board at the instance that they are appointed. The next submission is that we persist in our belief that there should be a time limit as to when the minister may make a recommendation to the president from the existing list of additional names before having to go out again on open advert. At present, the provincial legislature is proposing a 24 to 36 months, where the president can still choose from the same list even after 5 years. So we believe that it is, firstly, we do not support the notion or the submission that has been provided, because the bill already makes provision for the minister to initiate the relevant process if none of the additional names referred to is available to fill the vacancy that may arise during the term of the authority. The next provision of submission was in relation to Clause 38. Clause 38 deals with the establishment and constitution of the appeals authority. And the submission from the province was that a more comprehensive process should be provided for, similar to the way in which the members of the board are established or appointed. We noted that and we indicate that the matter will be dealt with as part of the regulations that we would want to issue to complement the implementation of the Act. The Limpopo Provincial Legislature is next, which also voted in favor of the bill, subject to the following proposals. The first, the bill primarily addresses township areas and does not adequately consider rural communities, and it does not adequately serve the interests of traditional leaders. We believe that, Honourable Chair, the matter is adequately covered in the bill as we have it, because the bill, especially in clause 27, makes ample provision for consultation with the institution of traditional leadership, and also it is a factor that must be considered when the demarcation authority will undertake determination and the redetermination of municipal boundaries. The next submission from the Limpopo Provincial Legislature was that there is a lack of public consultation regarding the demarcation of wards, which will have a negative effect. I must say, Honourable Chair, that the provisions or the golden thread that runs through the bill that we have before us is deepening to a much greater intensity the matter relating to public consultation and public participation. We have deepened this when it comes to outer boundary demarcation, determination and redetermination, but we've also subjected inner boundaries ward delimitation to a similar intensive public participation and citizen engagement process, something that is not there in the present provisions of Act number 27 of 1998. So we believe that this has been adequately provided for in the bill that we have before us. The next matter raised was that there is a lack of clarity on how municipalities are involved in disputes over wards that fall under the jurisdiction, and that there should also be a provincialization of the demarcation authorities' officers. Here too, we believe that these matters are covered, especially in clause 6 of the bill. The next matter raised was that the usage of the voters' roll while determining the municipality was mentioned as a cause of failure. Therefore, recommended IDs to be used for that purpose. We have not supported that. We believe that the use of the registered voters provides a credible source of verifiable and auditable population and data, since it takes into consideration the issues of migration. We will be wondering why the purple highlights. It is because it is an addition and it is not variable as provided for in the submission that was made to the committee. The next submission was in relation to clause 35, and the submission from the legislature was that it should be revised to specify whether headmen are included in the 15% provision. We've noted that, and as indicated in earlier on, that the 15% move to 30% is to ensure that there is traditional communities being kept together when the 15% becomes an impediment to ensure that splitting of the community. The next submission is in relation received from Mpumalanga. Here too, the legislature voted in favor of the bill, making the following proposals. One, most communities raise concerns on the demarcation bill not reaching to all people on the ground group level, meaning no proper consultation. Reasons already advanced, we have, in our view, provided for it in the bill already. The second matter submitted was that demarcation should do thorough verification through consultation with the houses of traditional leadership and the entire community. Here too, we believe that the matter is adequately provided for, especially in section or clause 24F of the bill as we have it. Third submission received from the provincial legislature was that there should be a determination of time for the handling of each appeal case. And a member who lodged an appeal should continuously be updated on any developments. And that the period of 30 days be increased to 60 days. For reasons advanced already, Chair, where we indicated that the matter is time-bound, without wanting to compromise other related activities, we would want to stick to the 30 days as provided for in the bill as we have it. The fourth submission from the legislature was that the process for the appointment of the board does not leave much room for the appointment of independent members of the board, and that the selection panel is laced with political connotations. We've noted that, but for the reasons advanced already, we believe that the matter is adequately and appropriately covered in the formulation of the provisions in relation to that specific matter. The next submission was that the proposal or suggestion that a more transparent or public process of nomination and interview process be followed. We've noted that, and we believe that the selection panel, as we have it in the bill, goes far beyond representation of only members of Parliament. The next submission dealt with the creation of a developmental local government system, and then also providing for officers closer to the people. The latter matter has been responded to already, and we believe that the matter relating to development local government is adequately catered for in clause 6 of the bill. The next submission from the legislature dealt with the challenge of the lack of resources that the board is subjected to, and which often hampers the board from conducting its work effectively. We believe it is already provided for and also responded to earlier on in the presentation that I am making. The next submission from the Northern Cape Province, essentially supporting the creation of the Independent Municipal Demarcation Authority, and it goes on to say that the IMDA will have the potential to promote greater professionalization, professionalism, safeguard the process from political manipulation, and that it will also enhance credibility and public trust in decision-making. We have noted the submission from the Northern Cape. The Northwest Provincial Legislature also voted in favor of the bill with the following proposed amendments. Firstly, that the board must enforce for a broad, continuous, consultative and educative process. We support that. We would want to see how we engage the drafters to incorporate this into the bill, and perhaps looking deeper into Section 5 of the Electoral Act will help guide us in terms of how we would want to take demarcation education closer to our people. The next clause, and this was specifically in relation to clause 35, where communities had sought clarity thereof and asking whether the clause will come into effect immediately or after the 2026 local government elections. The next matter related to the norm, followed by proper consultation, and then indicating that the bill does not stipulate adequate consequence management processes and procedures, and therefore the bill is referred back for its consideration. The communities had also raised concerns about the understanding of the 15% and the 30% norm. In response from the department, we've noted the submissions, and we believe that the transitional measures that would be included in the bill, the Act, will deal with the matter relating to when the criteria would come into operation. I suppose that as the board is presently coming to an end of its ward delimitation processes, I think, if memory serves me correct, it would be during December when final ward boundaries, finalized ward boundaries would be handed over to the IEC to enable the IEC to then commence with its processes. So I suppose that that would then come into effect after the next local government elections. In relation to the number of board members to be an even, we believe that the criteria or the casting vote that is now provided in the bill would cover situations when there is a deadlock. The intention of Clause 35 is to avoid the splitting of communities and therefore the 15% and the 30% migration to the latter. Perhaps this should be something that would become a priority when it comes to education around what ward delimitation movement, what the 15% and the 30% means within the context of avoiding the splitting of communities, etc. As indicated, public participation and deepening citizen engagement is the golden thread we believe that runs through the bill. We also believe that Clause 49 adequately deals with the matter relating to offences and penalties. And when one looks at 49, it clearly indicates that those that would be in trouble, if I can put it like that, would be a person who does not attend any public hearing when summoned to do so. We have sometimes found that persons living in another province would make the submission in relation to another province, and when asked to provide more clarity, that clarity is not forthcoming. So that could be an instance where a person could be falling foul of the provisions of the bill. Another instance could be that a person who does not produce documents as requested in summons that would be issued, and then that provision, the clause 49 goes on to also then deal with a fine and such imprisonment. The last province, the Western Cape province, is in their submission does not support the bill in its current form and proposes the following amendments. Firstly, to insert a definition for the president. We've supported that. And we've also provided a formulation as to how it could look, but of course subject to our legal drafters. The next submission from the provincial legislature dealt with the composition of the board, but more specifically that there should be more emphasis placed on gender. We've noted that. And we believe that by the inclusion of the chairperson of the Gender Commission on the selection panel, those interests would be taken care of. The next submission was in relation to the fiduciary responsibilities of the board should not be underestimated. It is recommended to include the following: for the board to act independently, exercise independent judgment, and take decisions according to the best interest of the institution. We believe that, Honourable Chairperson, that the matter is already covered in the bill when we say in Clause 4 that the authority must be independent, impartial, and perform its functions without fear, favour, or prejudice. The next submission deals with specifically in relation to Clause 9.2e, something that has been dealt with, a clause that has been commented on by other legislatures. Then to indicate, and the proposal was to amend clause 9(2)(e) as follows: that a person holding a political office or a person in a party political office as a proposal, which is not supported because we believe that the definition that we have provided for political office in the bill adequately covers the proposal being made by the provincial legislature. The next submission was in relation to the appointment of board members, more specifically clause 10(1)(b). And here too, it is indicated that the composition of the panel presents potential political influence, and that the selection panel presents opportunities for political interference. We've noted that, but for the reasons already advanced, we believe that the matter is adequately covered by the selection panel that is established and the various persons represented therein. The next clause related also to the appointment of board members, and it is indicated that it is a concern that the selection panel may determine its own procedures. We've noted that, and we believe that the selection panel may determine its own procedure, and that such procedure must be fair, transparent, as contemplated in clause 10(3). The next also deals with the appointment of board members, and that the default position for filling a vacancy on the board is to require the president, to fill the vacancy from the additional names in terms of subsection 5. Here too, we have not supported the submission, and that we believe that the bill already makes provision for the minister to initiate an appointment process if none of the additional names are available at the instance of a vacancy. The next submission proposal was for and indicated as follows: that members of the board are appointed on a part-time basis, except for the chairperson, whose appointment may be either full-time or part-time. It is a legal drafting proposal, and we will engage the legal drafters to ensure that the final version of this specific provision is not superfluous, and it is within, and it takes into consideration the challenges that have been raised by the provincial legislature. The next deals with clause 16(2)(a), committees, and no limitation on how many committees the board can appoint to assist with its performance of its functions. We have not supported the specific proposal, and we believe that, as provided for in section 15 of the bill, that this should be dealt with in terms of the board's rules of procedure. The next, also in relation to committees, that the criteria and qualifications for the co-opted members are not specified. We support this, as has been raised above as well, and we will redraft section 9 to ensure that the entire section is applicable to the committees. Furthermore, with no limits provided upfront for the co-option of members, it does not be open to creating a board within a board. We believe not, and because of that, we have not supported the proposal. This next submission was in relation to clause 19(3)(b), which deals with the chief executive officer of the board, and it raises the matter of seconded, and that there is no legal authorization of such secondment. The Public Administration Management Act is an example, and a definition can be incorporated under clause 1. We've noted this, and we believe that the conditions of employment of employees, including secondment, is broadly covered in clause 20 of the bill. And of course, that specific provision makes specific reference to the Public Administration Management Act as well. The next submission related to clause 24, which deals with factors to be taken into account. And the legislature had indicated that consideration should be given to the inclusion of bulk service provisions, particularly water catchment and service areas, which includes waste management. We believe that the matter is already covered in the list of factors that should be taken into account when boundaries are determined or redetermined, and therefore have not supported the proposal. The next submission was that consideration should be given to the inclusion of more measurable indicators. Factors, the category A municipality is too broad, especially when one takes note of the provisions indicating that a conurbation featuring an intense movement of goods. This formulation raises a number of questions, such as how does one quantify this? Consideration should be also taken of other factors, such as the South African functional town typology, work that is presently being undertaken by the CSIR. We've noted that, and we've indicated that perhaps this detail could be provided in regulations that we would want to provide, and also include matters such as the small town regeneration strategy of the department, integrated urban development framework of the department, and other national programs in auditors. The next submission was in relation to the clause dealing with the major boundary determinations of being done every 10 years, which major boundary determination, or major being defined as the movement of more than one whole ward in a municipality. It also goes on to say that if the factors listed in 24 have been considered and they point to the need to undertake such demarcations, it is unclear why the board must wait 10 years to do so. We have noted this. I've also responded to this in up above, but we believe that the introduction of the 10-year cycle or the 2 terms when one looks at the 5-year term of a local government is there or intended to limit challenges associated with amalgamations and to provide stability in municipalities. The next submission related to a reformulation of Section 32(4)(c), the reformulation by the deletion of the words in exceptional cases, including those referred to in Section 87 of the Municipal Structures Act. So basically to remove that reference, which we have not supported, because we believe that Section 87 especially is a necessary requirement, and Section 87 deals with the temporary allocation of functions and powers between Bs and Cs in instances when the one cannot perform the function, and the MEC would subject to engagement with the minister dealing with that temporary allocation. Clause 17 was the next submission that was made by the provincial legislature, and the suggestion that there should be a requirement for an interpreter to address the vernacular needs of the public in the region where such engagements or public consultation takes place. We have supported this, and we believe that the matter should be considered for addressing or inclusion in the regulations that we would want to have to complement implementation of the Act. The next dealt with public participation, and the submission is that the purposes of clarifying responsibilities in fulfilling this mandate, that there are clear provisions that relate to the costs associated with these public consultations. We've noted it. We believe that it should not be included in the legislation. The board is a constitutional institution and makes use of available facilities and resources from other state institutions, most notably from municipalities. The next dealt with the establishment and the constitution of the Appeals Authority, and the submission made was that it is suggested the current appointment process of the Appeals Authority is inadequate. There should be a more comprehensive appointment and interview process in place. Here too, we've noted it, and we believe that it is a matter for consideration in the regulations. The next and the last submission from the Western Cape Provincial Legislature related to the transitional arrangements that's provided for in the bill. And it indicates that the intention of the bill is to repeal the present Municipal Demarcation Act as contained in the schedule. The transitional arrangements as they currently stand should be revised. We have noted that, and we will undertake a further in-depth engagement with the legal drafters to ensure that all matters are covered as far as we can get to, and that the transitional arrangements do provide for that. Honorable Chairperson, that is the submission, the responses from the department in relation to the various submissions that have been received. I will stop here and hand back to the Honorable Chairperson to further guide us. Thank you very much.
Thank you very much, Dr. Naidu. We are now going to request legal units to give their perspective on the submissions. Then members will engage. We are left with an hour to do so, 1 hour and 30 minutes, including members' engagement.
Can I come in, Chairperson?
Yes, you can come, Advocate.
Yes. Greetings, Honorable Chairperson, honorable members, and greetings to my colleagues as well. Chairperson, we thought we should chip in on the sticky issues in which the department has invited comments from us as the Constitutional and Legal Services Office. Chairperson, I must indicate from the onset that we still have to confer with our colleagues from the Office of the Chief State Law Advisor and the department before other issues are finalized. However, we will be guided by members of this committee in their deliberations, and that should find expression in the series. Chairperson, the Constitutional and Legal Services Office has considered the Independent Municipal Demarcation Authority Bill, P14B of 2020. The various written submissions delivered to the Select Committee have also been considered. The Constitutional and Legal Services Office considered the legal and constitutional issues raised in these submissions, and the purpose of this presentation is to address only the legal and constitutional issues. Policy issues have been left to the executive to address or to deal with. Just as an introduction, Chairperson, the majority of the written submissions are in support of the bill. However, there were several drafting issues as well as constitutional issues raised by submitters. So for that reason, Chairperson, this presentation is divided into drafting and technical responses, together with responses relating to the constitutional content of the bill. Chairperson, we will start with the Eastern Cape one, and of course with clause 27. And Chairperson, you will see that in the submission of the province, because of the reach of the radio, as Dr. Naidu has referred to, they then submitted that radio should specifically be mentioned there. In our view, Chairperson, is that reference to any appropriate means of communication under clause 23 includes radio as a medium of communication. And that principle applies also to clause 29. We say reference to or through another media platform accessible to people living in the area. Under clause 29, 3 includes radio as a medium of communication as well. And we carry the same principle, Chairperson, to clause 26 on public participation, and reference to through another medium platform includes radio as a medium of communication. Chairperson, we then go to the issues relating to drafting submitted by the Western Cape. You will see, Chairperson, that from clause 11.4, term of office, termination and resignation of board members, the Western Cape is of the view that there might be some redundancy or disharmony when you read clause 13.1 and 11.4. And of course, the department has invited us to comment on this as well. The Western Cape has said members of the board are appointed on a part-time basis, except for the chairperson, whose appointment may either be full-time or part-time. But Chairperson, our view is that if you read both provisions, clause 13.1 provides for the appointment of the chairperson by the president and not full-time or part-time appointment. And in our view, there is neither redundancy nor disharmony with clause 11.4, that with 13.1. Now, Chairperson, on the Northwest one, under general, of course, it made the proposal that the board must enforce for a broad, continuous, consultative and educative process to the communities on the ward delimitation processes, so that the communities are well informed and empowered. And so we take the view that we will try and incorporate this, but of course, we'll first consult with our state law advisor and the department with a view to consider a similar provision from the Electoral Act relating to voter education. And then, Chairperson, if we go to the submission from the Free State, particularly on clause 9, qualifications of the board. So they have the view that on clause 9.2, clause 9.2 must be amended to ensure that the disqualification is extended to include individuals who have previously held political positions for a period of at least 12 months after holding a political office. And our view, Chairperson, is that what the committee needs to ask itself is what is the mischief that is thought to be resolved. If the mischief that is sought to be resolved is about clean governance and keeping a distance between decisions which holders of political office make whilst in office and the derivation of benefits from those decisions immediately thereafter, that is when they vacate office, then the inclusion seems to be rational. But that's our view, Chairperson. And then if we move to the submission by Gauteng on clause 11, which deals with the term of office, termination and resignation of board member. Clause 11, 8 AG, provides that subject to the promotion of Administrative Justice Act, the president may remove a member of the board from office on account of the minister's loss of confidence in the member. And of course, I think the view was that this could be arbitrary or capricious. And our view, Chairperson, is that PAJA gives effect to Section 33 of the Constitution, which guarantees the right to administrative action that is lawful, reasonable, and procedurally fair. The Act requires decision makers to follow fair procedures when making decisions, which may involve consulting with affected individuals. And the individuals have the right to receive adequate written reasons for administrative actions that negatively affect them. And PAJA gives the public the right to challenge administrative decisions in court on various grounds such as bias, prejudice, or illegality. And therefore, the Constitutional and Legal Services Office has no issues with the above clause, as its implementation is subject to PAJA. And then, Chairperson, again, on the constitutional and interpretational issues, there's a submission that was made by the Western Cape regarding clause 51(1) and 3 on transitional arrangements. And this is the submission by the Western Cape. It would not be possible to perform any functions or give any effect to the Municipal Demarcation Act, as the intention of the bill is to repeal the Municipal Demarcation Act as contained in the schedule to the bill. Therefore, the transitional arrangements as they currently stand should be revised to make enforceable current actions of the board when the bill takes effect. And Chairperson, even here, we will confer with the State Law Advisor and the department. And of course, after which, Chairperson, we hope that when members deliberate, they will also guide us, after which we should then find expression in the C list. Chairperson, because of time, I think I will stop there and wait for guidance. Thanks, Chairperson.
Thank you, Advocate Techana Andile. Techana, we now going to allow members to engage in the entirety of submissions and what formulated responses of the department and the legal advice that was just given by the legal team. And some of the matters, of course, will be conferred to the state attorney to give its own take on the matters. Members, by show of hands, can I get an indication of those who want to have a bite? Dr. Skirkocher, you are the first one. Any other member? I only see one hand. You'll be followed by Honorable Bedenhorst. For now, those are the two hands. Honorable Skirkocher, you can start.
Thank you, Chairperson. I'm going to start by just reminding us why we are here today and looking at the mandates again. On the 25th of October 2024, we had a resolution that we need to reopen public participation. And then it was then we met on the 18th of February 2025 again, where it said that the public participation should open on the 31st of March 2025 and then close on the 17th of April 2025, which will give provinces 8 weeks to do so. Chairperson, that being said, we are guided by its Rule 176 of the NCOP, which it's read with Section 59(1)A, Section 72(1)A, and Section 118(1)A of the Constitution, which allows us to say that we will have to give sufficient public participation to ensure that when bills go through. And I just want to read something here where it says it's a case of South African Iron and Steel Institution and others versus the Speaker of the National Assembly of 2023, where it says that I accept that Parliament and provincial legislature must be accorded a significant measure of discretion in determining how best to fulfill the duty to facilitate public participation. Now, Chairperson, through my research and what I have come across is that the only 3 of the 9 provinces, there's the Free State, the Northwest, and the Western Cape, that proper public participation, where they have actually called for, they had public they had public hearings, like the Northwest started on the 6th of May, the Free State did in March and April, like we requested, and so is the Western Cape on the 16th of April. But my concern is, Chairperson, that the Eastern Cape, KwaZulu-Natal, Limpopo, Mpumalanga, and the Northern Cape, including the Gauteng, only hosted virtual public participations. And if we remember in the previous report that we got on the 25th of October, the Namakwa region in Northern Cape said that they were not afforded any chance for public participation. So my request is that we need to be submitted from the secretary a full report on how public participation has been taken through all the provinces. Because furthermore, Chairperson, we said that, and we made a resolution that the closing date is the 17th of April. However, the NCOP only published input for written submission on the 29th of June of this year, with the closing date only the 30th of June. So that gives us 3 days for people to submit public participation. And then the NCOP went back and they backdated it to the 11th of June, which there's no explanation of. So, Chairperson, I have a very big concern, because public participation yet again didn't happen. That's why we restarted this process. So we need to be, as this committee, be provided a complete report. How did provinces do it? Why did these other 6 provinces decided to go on virtual? And then again, Northern Cape, which we know is absolutely vastness, and people don't have connectivity. And again, we need to make sure that public, and now that's the steel case. Honorable Barnes also mentioned another one to me this morning, that the Doctors for Life, again in 2006, which we had to restart this process because, to my knowledge, we did not do proper public participation, and precedents have been set in the High Court. And if we proceed with now this, I'm pretty sure that we can sit with court cases. So the Secretary must please, and also provide with us explanation why the NCOP only published on the 29th of June, but our deadline, and as noted in the minutes and resolutions, that the closing date is of the 17th of April. So that is my submission, because I am very much afraid that, Chairperson, that we did not yet again do proper public participation, because this is a bill that affects the public, it affects their awards, it affects their delimitation, and we cannot, that's our job, to go back to the people, and this was yet again not done. Thank you, Chairperson.
Honorable Perenost.
Chair, thank you very much. I'm partially covered by my colleague, and I must just submit that I support the proposal by Honorable Skierkogel 100%. One of the strategic directives of the 7th Parliament is meaningful, inclusive and transparent public participation. This has also been part of the NCOP strategic plan, as you recall, when we started with the 7th Parliament, that we would always ensure in our oversight that we have proper public participation in a transparent way, which is inclusive and reasoned. I'm afraid we have not ticked that box in this part of our oversight. We would need to have a report that indicates exactly what public notices went out, whether it's in newspapers or radio or social media or on legislatures' websites, and how much lead time was given. We need to find out how much accessibility was afforded with regards to translations of the bill, in how many languages, and we need to know what opportunity was given to the public with regards to participation in the process and in which way. Was it physical? Was it only by online meetings? Was there enough time, like Honourable Skeerkogel said, for written submissions? Was proper records kept of and summaries of inputs and responses by the provinces during the public participation process? And obviously, was there enough time? We will find ourselves, I think, on the wrong side of the law, and we will definitely not be doing our jobs as legislators properly if we don't ensure that this process was followed properly. I want to remind the committee that the whole reason this bill is sitting with us at the moment and the process that we've gone through is because there was a lack of proper public participation in the sixth Parliament. And I'm afraid if we don't double check that proper public participation was done while we're waiting, we can do this between now and while we're waiting for the final mandates to come back from provinces. We will not be doing our job properly as in the oversight portion of our work. That's my submission. Thank you very much, Chair.
Honourable Priyat.
Thank you, Chairperson. I'm not sure if Honourable Badenhorst seconded the proposal by Dr. Skeerkogel, but I would like to come in here and say, and maybe just reiterate and add my voice of support. I want to thank, I think the department and the our legal services for their inputs and opinions, but I do think that this is an exceptional bill, and considering the fact that we had that meeting, I think it was still in Marks 46, where we had the initial meeting where we decided that public participation was not done correctly. And I would like to remind colleagues that the NCOP has been found lacking in terms of public participation in the past, specifically in terms of, and I cannot remember, I think it was legislation in terms of animal welfare, that the court recently actually found the NCOP was in contravention and did not do proper public participation. So I think for the sake of transparency and clarity, it might just be good and due diligence for us to, as Honourable Skeerkogel and Badenhorst has stated, just to get a report from provinces, or maybe Mr. Manele and the committee staff can provide that to us, a brief about what was done, what was not done, because specifically taking into account your larger provinces, your Northern Capes, even your Limpopos and Mpumalangas that are very rural, it is very pertinent that not just opportunities for virtual be given, but actually physical meetings take place. We saw that was a lack, specifically coming from COVID. So, Chairperson, without speaking too long, I would just like to support that. I think it's good that we do our due diligence and double check that the provinces have done public participation, because if Honourable Skeerkogel is correct that only 3 out of the 9 provinces did proper public participation, I am worried that we will be going into more litigation, and I don't think we can afford that. Thank you.
Thank you, honourable members. There are no further hands. Oh, Honourable Nzimande, I see your hand.
Oh, Shalo. Musungumangaza.
Yeah, ngena Nzimande, siyakubona nawe nekhala yakho la.
Yeah,
Please note me, Chair. I can't raise my hand.
You TTC, Chair.
Okay, Honourable Whip.
Chairperson, I think there is a problem here. And I don't think this committee should be used to be a stepping stone for people to try and make a case in support of their own organizational positions. Umkhonto weSizwe has its own position on this matter. However, we don't second guess the mandate we are given by the province, that they have done all necessary things building up to this mandate we are given. And two, there's nothing that suggests that public participation should be conventional and only conventional. I hear the colleagues, they are just talking about it was visual. So what? Why that should be a problem? I don't think it gives us any justification to second guess what the provinces have done and to start now calling for information and want to punch holes whether there are gaps in what they've done or not. For now and today, we believe we have one objective as a committee, to consider what the provinces have tabled, and we have tabled that as provinces, and we believe all necessary steps have been taken. Whoever who second guess what the provinces have done should then not try and use this committee. And I believe that for chairperson, there's no reason and no justification to second guess and a call for the provinces to justify whether they've done it in a conventional way or not, whether they have registers or not. We don't second guess that. So we really object to what these three parties or one party has now tabled, coming from two provinces. Thank you.
Thank you. Honorable Molokome.
Thank you, Chairperson, and thanks for the opportunity. Yeah, I wasn't aware of my background, Chair. No, Chair, I just want to concur with Honorable Mzimande.
We can see your twin sister.
No, thanks, Chair. I just want to concur with what Honorable Mzimande has just said concerning the provinces that has submitted their mandates. And remember, honorable members, this committee gave provinces enough time to go back. I think it's 8 weeks, Chairperson. I think Honorable Skrikogen has given the dates and times and weeks that these provinces were given for them to be able to go back again and consult. And on the report, I haven't seen even one province that is complaining about the time that were given, and also because of that, I don't think we should really want to delay the process further. So I think the provinces has consulted whether they made it physical or visual meetings from each province, because we can't come here and determine what is what provinces are supposed to do in terms of them consulting their communities. I think they know their provinces better than us, Chairperson. So I just want to say let's proceed and take mandates from the provinces as submitted, and we move forward with the submissions. Only one province has not supported, and 8 provinces has supported the mandates. So I mean the bill itself. So I think is important and necessary that we move on, Chair, with what is submitted from the provinces. Thank you very much.
Thank you, honorable members. We will use next week, Tuesday, in our meeting to just give assurance on how provinces and how their consultations unfolded, which is not hidden. the team will have to consolidate that, because for now, the picture that we have received is from the comments of members. Then we'll go ahead with the process. I'm sure if there are people who like to challenge the process, they'll be at liberty to do so, because the constitution of this country allows transparency and accountability from the legislators. So let's hold it there, members. I didn't hear any member making a comment on the submission. The only thing which I would like to check from the department when they responded was the issue of submission by Free State, where they were proposing that in the board, organized local government must also be represented. I'll assume that is SALGA. I didn't hear you. What you said, no, the structure is adequately represented. But I didn't hear you about this direct request, because they submitted a direct request that organized local government must be represented. Is SALGA represented in the board? If maybe I missed that part. Dr. Naidu?
Indeed, Chair, there were two inputs in relation to, and not necessarily both from the Free State. The one was that there should be an insertion of the definition of organized local government in the bill, which we have accepted. And the second, and to answer your question, yes, organized local government is represented in the selection panel for the recruitment of board members. So that is covered there. Whether the organized local government would be represented in the board would be informed by the selection process that would be undertaken. And if a person from organized local government is successful, then he or she would be on the board. Thank you, Chair.
Thank you. Covered by your response, Dr. Naidu. Let me take this opportunity to thank you for having consolidated the report and the responses to all the issues raised by provinces, and also our legal desk team for having responded to legal and constitutional matters raised. We know that there are a lot of bills, so you'll be busy, very busy. There are some bills which are still being processed by the National Assembly, which are still forthcoming to our committee, including the water amendment bill and other bills. So there will be a lot of work that this committee will be seized with. And our provinces are also really overstrained by all these bills coming at the same time. We should also recognize that when we deliberate and when we engage with our provinces, there's a lot. They've got their own programs that they are running, but also the responsibility, which is their constitutional responsibility, to process some of these bills. They need to conduct thorough consultations with the members of the public and the stakeholders. So with that being said, thank you very much. This is the first session which has come to an end. We are now going to be moving to the minutes of our committee. I'm hoping that members have received the 2 sets of minutes.
Chair, there's a hand up.
Oh, okay. Honorable Skil Cocker.
Thank you, Chen. I just want to confirm, so you are in agreement that the staff will just for our next session prepare a report of the public participation, and that you are fully in agreement that we need a transparent process, and just so that we are all clear. So if I'm correct, that is what you said in your closing remarks, that they must just give us a report next week. Thank you, Chair.
Yeah, in the next meeting, we'll just confirm that, because for now, the team was not in a position to present a consolidated report in terms of public hearings. So they'll consolidate that and give us on Tuesday next week. That doesn't change the mandates of the provinces. Thank you.
Thank you, Chair.
Thank you. Can we move to the minutes, colleagues? We've got 2 sets of minutes which are going to be dealt with, and members have received those 2 sets of minutes. I'm hoping that we can now be in a position to adopt or to correct those sets of minutes from our secretariat. Can we start with the first set of minutes of the 16th of September? If you can just scroll up so that members can see.
Honorable Chair,
Yes.
I request to be excused from the meeting, and perhaps my team as well.
No, thank you very much, Dr. Naidoo and your team. You are released. You can take leave. Thank you. Job well done.
Thank you very much, Honorable Chairperson.
Thank you.
Honorable Chair, can you also extend that liberty to me?
Yes, so that you can look at other legal matters.
Yes.
Let's release you.
Thank you very much, Chairperson.
Thank you. Thank you.
Thank you.
All right. Members, can I get any member who wishes to make corrections before we adopt? Any corrections? No. Can we get a mover for the minutes if they are a true reflection of what transpired? Just be certain that you were present in that meeting when you move. Honorable Molokome?
I move for the adoption of the minutes, Chair, as the true reflection of what transpired on that day.
Thank you very much, Honorable Molokome. Any seconder? Any seconder? I don't see. Honorable Skirkoka? Honorable Skirkoka seconds. The minutes are duly adopted. Any matter that is arising from these minutes before we move to the second set? No. Okay, let's move to the second set. The minutes of the 25th of September. Okay. Any corrections? Let's scroll them up. Any corrections? If not, can I get a mover and a seconder respectively?
I'll move, Chair.
Honorable Berenhouse, move. Any seconder?
I'll second, Chair.
Thank you. Honorable Skirkoker seconds. The minutes are now our legal documents for consumption, for public consumption. Thank you very much, honorable members. This brings us to an end of our meeting. And I'll request members to continue liaising with our secretariat in preparation for the Free State visit on Nala, and we are proposing that we all come back on the same day after we are done with our work in Free State, because we are trying to deal with cost saving. We sleep for one night, then we come back the following day after dealing with our oversight work. Let's just deal with those nitty-gritties, and we urge members to be present in that oversight visit, and we'll be finalizing with the whip of the committee and the board chairpersons on the joint oversight to Northwest the following week. Next week, we'll finalize that and we'll brief members on the proceedings. Thank you very much. The meeting is now formally adjourned. Thank you. You can go and have lunch in your respective. There is no plenary today. Don't rush for a plenary. We'll meet tomorrow. Thank you. The meeting is
Thank you,
adjourned.
Chair. Goodbye, colleagues.
Thank you.
Thank you, Chairperson.
Thank you.
Chair.
Thank you. Sisengawubona nama backgrounds. It's fine.
Yeah. So, these gadgets, they keep on changing.
I-gadget ayenzanga lutho.
Chair, I thought my gadget is still on where I left it, but hey, I'm exposed.
No, but let's thank the gadget. It did the good job. Thank you very much.
Thank you, Chair. Bye.
Bye.